Welcome once again to my channel. My name is Msimi Rex, and basically today we want to look at one of the important topics in the contract law one, which is privity of a contract. Want to look at the law governing it. Want to also look at the origin. Want to also look at its exceptions. Where did it come from? How did it come to be in in a contract law? Okay. So, of course, before I move on, I would love to encourage you to subscribe, share with friends, and always leave a comment when you find it necessary. So, uh, uh, privity of a contract is an important doctrine. It's actually a common law doctrine, which holds that a person who is not a party to a contract cannot enforce that contract. And we need to know that common law applies in Uganda uh, when you look at section 14 of the Judicature Act of Uganda. So that section allows common law to apply in Uganda. Thus, that common law, that doctrine of privity of a contract is applicable in Ugandan law. And it is also important to know that this doctrine has been decided, has been actually upheld and applied and developed in several decisions right from England from 19th century up to now. The doctrine is still applying. And of course, for purposes of understanding it very well, you need to look at the decision of Dunlop versus Selfridge. Dunlop versus Selfridge. I need to look at the decisions of Prince versus Easton. You need to look at the decisions of Trido versus Atkinson. For example, in the case of Trido versus Atkinson, this was a boy and a girl who intended to marry. They actually they didn't have a plan of getting married, but their parents, the parent of a groom and the parent of a bridegroom, they encouraged them that if you actually get married, we shall contribute some money to you. We shall give you some money. And they went on and married. But when they married, now the parents of the girl did not pay that money. So now the boy suing the parents that they didn't honor their obligation that they had actually incurred. And of course, court held that uh, uh, this boy was not a party to the contract. Therefore, he could not enforce it. That the contract was only between the parents, their parents, because it's the parents that had agreed with each other that we pray that these people get married. We shall contribute some money towards their whatever. So when he sued, court observed that you cannot enforce this contract because you are not a party to a contract, that the contract was only between your parents, the parents of your wife and your parents. So you are not a party to the contract. So that is what it is, privity to the contract. That if you're not a party to the contract, you cannot enforce that contract. Okay, that is important for you to appreciate. The same principle was upheld in the Prince versus Easton. Actually, when you look at the case of Tweedle versus Atkinson, in Tweedle versus Atkinson, they referred to Prince versus Easton to uphold the principle regarding a privity of a contract. That's where they say that if you're not a party to a contract, there is no any way you can enforce that contract. Okay, so that is very, very important. Of course, still, even in Ugandan jurisprudence, the same has been upheld. You may need to check with the URI and get those decisions where uh, privity of a contract has been upheld and upheld and upheld. Okay, so as I earlier mentioned, the doctrine is not absolute. The doctrine is subject to exceptions. Like in law, every general rule has an exception. So even this general principle of if you're not a party to a contract, you cannot enforce it. It also has exceptions, and they are also important that you look at them and understand them. For example, Basically, these exceptions hold that there are situations where a person who is not a party to contract can actually enforce that contract. For example, you look at the exceptions like agency. If a person is acting as an agent of the other, uh, the third party can enforce the contract against the principal. You look at an exception like assignment. You look at bills of exchange. You look at restrictive covenants. You look at third party rights. You look at many other exceptions. However, uh, there is a video on this channel that explains those exceptions, about 10. So you may need to check out and look at those exceptions and appreciate them the more. But of course, it is important that even before you look at this privity and whatever, always take your mind back and appreciate what is a contract and what are the major elements. Okay, so but of course, it is also important to give you a clear definition of what is a contract. And a contract is defined under Section 9, subsection 1 of Contracts Act, and it holds that a contract is an agreement made with free consent of the parties with capacity to contract with an intention to create legal relations, but of course with a lawful object and with a lawful consideration. Look at Section 9, subsection 1. It will give you the best insight regarding what is a contract. Of course, you need to know that the contract can be in writing and the contract can also be written, can be written and can be in oral, can be made orally. You can speak and a contract is made. But of course, you need to know that a contract that exceeds 25 currency points, that contract must be in writing. So if a contract exceeds 500,000, that contract in Ugandan law, that contract must be in writing. Otherwise, check it out. Check out that video on exception to the privity of contract and appreciate it the more. Thank you. Thank you so much. Thank you for watching. Share with friends. Remember to subscribe to this channel. There are many other videos on this channel that you may need for purposes of appreciating the law. Thank you so much. God bless you.